Hey everybody, how's it going? Hope you're having a lovely day. I've talked a lot in this channel about the decline of ownership, and there's a few laws that got passed recently that I thought would make some progress in trying to push back against this. One of the clear-cut examples that I've used many times, because I just think it's a great one, comes from Sony and Discovery. As of December 31st, 2023, due to our content licensing arrangements with content providers, you will no longer be able to watch any of your previously purchased, not streamed, not rented, purchased Discovery content, and the content will be removed from your video library. We sincerely thank you for your continued support. Thank you, PlayStation Store. And the reason we're able to do this is because in their terms and conditions, on page 21, they have redefined the word own, ownership, purchase, sale, sold, sell, rent, or buy to not mean transfer of ownership, which is what it has meant since the 14th century. So what this law in California sought to do was change this a little bit, where if you are going to use the word purchase or buy or sell or sold, and you're not actually allowing the person to own it by what a reasonable person would believe the word own means, you have now broken the law in the state of California. I thought this was a fairly good bill. This bill would additionally prohibit the seller of a digital good from advertising or offering for sale a digital good as defined to a purchaser with the terms buy, purchase, or any other term which a reasonable person would understand to confer an unrestricted ownership interest in the digital good. It goes on with a bunch of legalese over here that I went over in the video I did on this. I thought I would try and test if this was a real working bill. Like Tato. Tato is good at testing stuff, right? If Tato can test, why can't I? I want to see if California really loves me. When I go over to the article that I have on consumerrights.wiki over here, you'll see that they have a very interesting case. When you go to their website to buy a textbook, you'll see that you can buy a textbook in the state of California with a lifetime license. And the lifetime license costs almost twice as much as the 180-day license. However, when you scroll down, you don't get something that says lifetime does not mean lifetime. You don't get something that says lifetime means we can revoke it whenever we want. You get this is a digital license in really small font all the way at the bottom with a details button. And that's it. That's not going to tell a reasonable person that this is something that can be revoked at any given time. And when you take a look at their actual terms, they're not great. 5 years of online platform access, ability to download content to a supported device during this period, and supported limited to a device compatibility at the time of download. And a device that's supported today cannot be supported tomorrow. It doesn't even say that you get access for 5 years. It says typically 5 years, which means they can change it whenever they want. You may permanently download the product to a supported device. Permanent, but to a supported device. And devices are no longer supported after a set period of time. This is not like downloading a PDF file on your Windows 2000 computer and then opening it up 25 years later. It will work as long as the device is supported. It's not a file that you own. It is something that must connect to their server in order to work. This was a fairly open and shut case. So what I asked people to do in my audience was file a complaint using the links that I provided and then CC me a copy of their complaint so that I could see it. And then that would allow me to also follow up with each of the members of my audience that did this so that I could figure out if they actually took this seriously. So I wanted to read you some of the emails that I received back from my audience about 6 weeks later after checking in with everybody. Thanks for checking up on this. Sadly, no, I got nothing yet besides that original confirmation that it's been submitted that I screenshotted and sent to you. Next. Not that I'm aware, I haven't received a thing. Next, I reviewed all my mail for the last month and can confirm and attest to the following. 1. I did not receive any confirmation of my complaint. 2. The AG's office has not contacted me in any way. Email, text, phone call, letters, or visits. Best. Next, I have not received any confirmation or request for information. It's just crickets over here. Sent with Spark. Hey Lewis, I just ran through my entire inbox from May 8th to today and didn't see any emails from their office. I've also occasionally perused my spam folder to ensure they didn't end up there, and the times that I checked it, I don't recall seeing one. No physical letters were received either. Unfortunately, the only messaging I've received from the state, both digital and physical, are reminders to renew my vehicle registration for $300, which is a reminder for me to quickly resolve my speed run of living in California. Been here 2 years so far, and I'm committed to no more than 2 to 3 years before I make my exit. Hi Lewis, I never received a response from the California Attorney General's office about my online complaint submission. Hello, Lewis. Unfortunately, I haven't even received a pro forma AC. Pro forma AC. I'm sure that means something to him, but I don't know what that is. Unfortunately, I haven't even received a pro forma AC since I submitted it. If that changes, I'll be sure to forward it over. I'm also going to reach out to the AG's office and ask for a response or status. I'll let you know how they respond. Hello, Lewis. I have not received anything from the California Attorney General's office beyond the initial email I sent you. I've yet to be given an update from their office. If I do receive anything, I'll forward it to you. Laws don't mean anything unless they're enforced. Now, I know what some of you may be thinking. Lewis, with all the stuff that started happening in the beginning of June in California, you think they have time for this? I made this video on May 8th. We're not talking about acting on it. We're not talking about the company getting a penalty or even getting a letter written to them. We're talking about acknowledging the people who live in California who sent something to their representative. I file a chargeback on Gold's Gym, and Chase Bank will get back to me faster than this. Government, If you run a business and you are slower at getting back to your customers than Chase Bank is at getting back to me, that's a fact. This is an obvious and blatant example. It's from a company that there's virtually no sympathy for, because everybody, whether you're an average Joe like me who could barely pass high school, or you're somebody who has a PhD, understands that the entire college textbook system is a scam, that would be a fairly easy win. We're talking about the people that made the complaint never even hearing back after a month and a half. I give California an A for effort, an F for practical application. At the end of the day, there is no point in consumer protection legislation if it's useless. And this, in my opinion, is functionally useless. I just wanted to follow up with this since it's been about a month and a half, and that's that. That's it for today. And as always, I hope you learned something. You don't really know what you bought and paid for. And if you thought you did in California because you had this law, not really. They don't give a shit. See you in the next one. Bye now.